537, State of Wisconsin versus Jared Stewart. The state appears through District Attorney Kevin Schmidt in person. Mr. Stewart appears in person with his counsel. And you're Mr. Graham?
Correct, Your Honor.
Zachary Graham. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Graham, please recite it for the record.
Thank you, Your Honor. The agreement would call for Mr. Stewart to plead guilty to count 5, manufacture THC under a deferred judgment of conviction for 3 years. He would also plead guilty to a misdemeanor count of possessing THC, getting convicted on that misdemeanor count. Withheld sentence with or without the PSI, pay costs, and then probation being that he have no use or possession of non-prescribed controlled substances, do an AODA evaluation, follow the regs, and then counts 4 and 6 would be dismissed and read in.
Why the difference in the agreements?
Originally, I sent an offer where it would be the same for both of them. When they contacted me back, he has actual job consequences where the conviction on that one count would be extremely negative for him and harm the family household. I responded back, so long as one of them was actually convicted of it, I'd be fine with the DGOC on the other, especially since there'd be supervision in the home. And my mind was, I really was more concerned about protecting the child than the other things, given this circumstances I already described in the public interest and sentencing argument in the other case.
Am I remembering correctly that you have military background?
Yes, I'm the National Guard, Your Honor.
Okay, so then that would be the impact. And Mr. Graham, you thoroughly researched the conviction of a misdemeanor of the same?
We have, Your Honor. There's a potential that the federal government will determine him as an unlawful user of a controlled substance, and then he would have potential firearm ramifications. The plea here doesn't involve using. In my experience, that typically will sometimes bar you from purchasing a new firearm, but it's not going to do anything to affect your current firearm rights. So given that, I think this is the safest way while still taking accountability to address this case in an appropriate way and also hopefully protect his guard service moving forward.
How long have you been married?
11 years, if I remember correctly.
Ms. Stewart, how long have you been married?
12 years,
Well,
12 years.
All right. And, I usually, I don't delve into the personal aspects of these kinds of things, but I get protecting the family unit, and in the end, it's protecting your young daughter who is, well, you heard what I talked to your wife about, but you both thoroughly talked about this and you're okay with it?
Sure.
Okay. I understand the ramifications of employment. And I understand needing to provide for your family. Are you the breadwinner?
Your Honor, I'd submit that they both contribute to
Oh, they
financially supporting the household.
both pretty dual.
Yes.
Okay.
Yes.
We're just worried about how this is going to impact your ability to be in the guards.
Yes, Your Honor.
Okay. All right. Plea questionnaire waiver of rights form, deferred judgment of conviction.
Yes, Your Honor.
Should you bring them up? Thank you. So I do have in front of me both of these documents, Mr. Stewart. Did your attorney thoroughly go over these documents with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Is that your signature on the second page of both documents?
Yes, Your Honor.
Formal motion to amend, I don't know which count you're amending, count 1 or count 4? Or you're adding?
Yeah,
a
it'd have to be
count?
count 4 because the DGOC is on count
5.
5. Yeah.
So amending count 4 to possession of THC simple,
So made.
granted. So you are pleading guilty to 2 counts here, Mr. Stewart. 1 count of possession of THC tetrahydrocannabinols simple. That means as a misdemeanor without anything else. And you're pleading guilty to the manufacturing, delivering THC greater than 200 but less than 1,000 grams as a party to a crime. Is that correct?
Yes, Your Honor.
You're 49 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or medications within the last 24 hours. No mental illnesses or disorders.
Yes, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of both of those documents. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty to these counts, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that you are pleading guilty to one felony count, but the court is being asked to have that as a deferred judgment of conviction? Do you understand that if I accept the deferred judgment of conviction, this won't come into play, the no use or possession of a firearm for life and no voting in any election until your civil rights are restored?
Yes, Your Honor.
But do you understand that if at any time the court enters judgment, revokes this document, this deferred judgment of conviction, and that means you will be convicted, it will be entered, and you will be sentenced on the felony? Do you understand at that time you may no longer use or possess a firearm?
Yes, Your Honor.
Do you understand that if you currently do use or possess firearms, another ramification on the family unit is that they must be locked with you only possessing the key and knowing where that is? Do you understand that?
Yes, Your Honor.
Do you understand that here the state would have to prove on or around February 26, 2025, you possessed a substance, the substance was a controlled substance that contains THC, and that you knew or believed that substance was a controlled substance containing THC? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a $5,000 fine or up to 6 months of incarceration, or both?
Yes, Your Honor.
Do you understand that as it relates to count 5, manufacturing THC greater than 200 grams but less than 1,000 grams as a party to a crime, the state would have to prove on or around February 26, 2025 in Burnett County, Wisconsin, as a party to a crime, you manufactured a controlled substance, to wit, tetrahydrocannabinols, in an amount of more than 200 grams, but not more than 1,000 grams, or more than 4 plants containing the THC, but not more than 20 plants containing THC. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years, or both?
Yes, Your Honor.
Do you understand that with that charge, it is a party to a crime? Do you understand what that means?
Yes, Your Honor.
Do you understand it? It means either you directly committed the crime yourself, you aided and abetted the person who is committing the crime, or you conspired with one or more people to commit the crime, and affirmative steps were taken towards the commission of that crime. Do you understand what party to a crime means?
Yes, Your Honor.
Do you understand that there is an agreement that's been recited on the record? But do you understand I'm not bound to follow that?
Yes, Your Honor.
Said differently, I could sentence you all the way up to the maximum possible penalty for the THC charge, and I do not have to accept that deferred judgment of conviction. Do you understand that?
Yes, Your Honor.
And I could sentence you to the maximum penalties. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter guilty pleas?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney, in particular that section called the probable cause section, where it basically says what happened around that time and why you were charged with the crime?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty today to possession of THC because you are guilty?
Yes, Your Honor.
Are you pleading guilty to manufacturing THC greater than 200 but less than 1,000 grams because you are guilty?
Yes, Your Honor.
May the court use the probable cause section of the criminal complaint along with the statements made by your client, Mr. Graham, to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Stewart, for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Has he discussed the discovery, the evidence with you, and you've discussed it with him?
Yes, Your Honor.
Has he discussed with you a potential for any legal defenses or a lack of defenses?
Yes, Your Honor.
Are you satisfied with his services?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to amended count 4, possession of THC as a misdemeanor, how do you wish to plead?
Guilty.
As to count 5, manufacturing, delivering THC, an H felony as a party to a crime, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those charges. A judgment of conviction will be entered as to count 4. As to count 5, the court will hear argument as to whether to accept the deferred judgment of conviction. Mr. Schmidt.
As I've already outlined, there will be actual convictions in both these cases for accountability purposes. There will be some degree of supervision to make sure that their daughter isn't being further exposed. Like I said, the most I'll say on evidence for it going outside the home, there's circumstantial evidence. It is speculative. There may still be consequences to Mr. Stewart because of the misdemeanor THC conviction. We probably won't know for a few months yet if there will or won't, as I'm sure the court's probably aware that federal prohibition for THC and drug offenses, that's in front of the Supreme Court of the United States right now, and they seem likely to strike it down. Thank you.
Thank you. Mr. Graham.
Thank you, Your Honor. A lot of the particular circumstances were discussed in the previous case, but just for the record in this case, I would note that Mr. Stewart has a very limited criminal history. He is a veteran that's done 2 tours of duty in Iraq. He's been married to his wife for 12 years, not 11. And, this was a discussion that they had as a family. We thank the state for exercising their discretion and not making both of this child's parents, convicted felons and preserving their ability to provide for the family. I would note that, this was kind of a product. The Stewarts are kind of entrepreneurial folks. They do a lot of things on their own, like growing honey. A lot of the plants that were seized as part of this offense was actually mint. And as Ms. Campion said in the previous case, some of it was also marijuana. They're kind of self-reliant individuals. And obviously, they have made a poor choice here to include marijuana in those pursuits. But as noted in the previous case, every state that borders Wisconsin, this would be legal, right? That's obviously the legislature's decision, not any of ours, but I think that it was limited to the home. It wasn't some massive distribution operation. Mr. Stewart has been cooperative in taking responsibility for this. He does serve in the National Guard. We are hopeful that this resolution will allow him to continue to do that. And Mr. Stewart did ask me to say that he is a little bit anxious about speaking himself, but they of course have not put any negative feelings on their daughter about this. They've been supportive of her throughout. They said she did the right thing. It's their mistake, not hers. And I think they have kind of been forthright about that and addressed it as a family. And they're showing her that when you make mistakes, you take accountability for it. And I think that it's going to be a healthier situation for all of them moving forward. So given all of those factors, I think it is an appropriate resolution. In terms of the gravity of the offense, I don't think that the public is served by him getting convicted of the felony and not being able to serve in the Guard anymore. And in terms of rehabilitative needs, I think that he's had a pretty eye-opening experience already in spending 2 nights in jail, being charged with a felony, watching what his wife has had to go through as well. And I think that, the AODA assessment and probation, which is twice as long as his wife's now with the deferred judgments, I think will kind of drive home the point. And I don't think any jail, certainly not prison, would do anything to add to that education for him.
All right, thank you. Mr. Stewart, is there anything else you would like to add? And again, you don't have to, but it's your only opportunity to say anything about this case if you want to.
I'm okay, Your Honor. Thank you.
You sat here, as did your attorney, when I went through everything with your wife. So I'm not going to rehash all of the same things over again. Usually I take pleas in cases like this together. Something told me, I guess, not to call you both up, and I guess then I was told that they're not the same charges, so it's a good thing I didn't. But again, I'm not going to reiterate or say again what I told to Mrs. Stewart. This is serious in the fact that your child was put right in the middle of all of this, and I think you know that. It is serious in the fact that it does potentially negatively impact your ability to continue to serve in the guards. First and foremost, I respect you and applaud you for being a veteran and doing what you do and what you have done. It comes with significant costs, but a lot of benefits to our country. And so thank you for serving. And it leads me to these charges. And wondering, are you receiving any type of veteran services? Are you engaged in any type of counseling or any type of therapies or anything like that?
I am not, Your Honor.
You are not?
No.
And I can speculate as to why the THC is involved. I don't know for sure. I just know the studies that I've read as it relates to THC and all of those things. And PTSD and those things. But if that's the reason why this was involved, you were involved in this, you need to find other avenues. Because it could be far more serious for you and far more serious for your wife and extremely far more serious for your daughter.
Your Honor.
I think she has seen great examples of parents up to now. But again, I don't know you from Adam. I only know you both from, I think this is the first time I've seen you in person, but I can't recall. So I don't know how you are in real life. In this life, in these walls, you appear to be parents that love your daughter, that respect the country, respect our rules and our laws, except here. And again, I can't change the law. I don't write the law. I don't recommend the law. All I do is interpret the law and apply the law. And here, that's what I'm doing. There could be so much empathy. There could be sympathy. There could be both. There could be all of those things. As a human, as a judge, I have to look at what the laws of our state are and go by that. I really hope that if you are in need of services that you do reach out. I know that there are some really great, I love the St. Cloud Veterans services there in St. Cloud. They are tremendous. I don't know if you've met Ella here in our Burnett County. She is amazing. And so she is a good resource if you need anything and to do that. I would hate to see, and it was pretty close, that a whole lot of work and a whole lot of defending our country almost went down the tubes. You know what I mean?
Yes,
What I'm saying.
Yes,
And that's sad for me. It's sad for you and it's sad for your family. I will accept the deferred judgment of conviction document. I am going to stress the number one reason I see that the state asked to have these documents revoked and for the court to enter judgment is paying the $150 within 60 days. I do that today if you have the ability to do that. The number two reason is getting that AODA assessment and that proof within 90 days two top reasons, and those are the easiest things to take care of and to handle right away. This will last for 36 months. It's a long time. It's a long time to be hanging over your head. But as I stated to Mrs. Stewart, I don't think that I'm going to be seeing you again in my courtroom. How long have you lived in Burnett County?
Since 2006.
Okay, all right, then this is the first time. Sometimes I have people going through severe things, veterans going through severe things, and I see them a lot more frequently. This is the first time I've ever seen you use your resources. Sounds like you've been doing well so far. I'm going to follow the recommendation for probation with the possession of THC, 1 year of probation. I'm doing a straight fine of $500. You have that paid. The AODA assessment and follow through, you have to do that anyway. Absolute sobriety. I can't recall other conditions. Regular drug and alcohol testing with your agent. And I'm just gonna say that you've met with Ella before?
Yes, yes.
Okay, then I just really wanted to make sure that you have met with her and talked with her. So I'm not gonna order that you do that. Doesn't sound like you need to. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA, and what you're gonna need to do is get the form, go to the jail and provide that. You have the ability to request it be expunged through a written letter to the Wisconsin Department of Justice, not to me, to the Department of Justice. It's easy to do. Google it or ask Mr. Graham. He can help you. You must report to probation immediately. So once you're done with the DNA, go to probation and get everything set up and ready to go. 2 days of jail if you are revoked. This is a withheld sentence, not an imposed and stayed. Mr. Schmidt, what am I missing?
Nothing from me.
Did you dismiss the other counts, Your Honor?
Sure did.
Okay, then nothing else.
All right. Thank you. Good luck to both of you. And just keep reiterating, keep telling your daughter, make sure that she knows for positive and true. She did nothing wrong and you don't blame her one bit.
Yes, Your Honor. Thank you.